SJC-11784, Commonwealth versus Waweru.
Mr. Goldman, good morning.
Good morning, Your Honor. May it please the Court. Richard Goldman for Mr. Waweru. The defendant's statement was admitted into trial against him improperly for two main reasons. First, it was involuntary, and second, it was admitted it was a privileged statement made to a psychiatrist during the course of treatment or diagnosis and was admitted in violation of 233-20B. Just the circumstances of the statement, as Your Honors, I'm sure, aware, but just a quick review. The defendant was arrested shortly after the incident and within an hour or so, taken to the hospital. When the police found him in his apartment, they determined that he had taken medication, that he overdosed or he was in physical distress. They called an ambulance to take him to the hospital. He was arrested, but he wasn't questioned by the police at the apartment, but he was placed under arrest. At the hospital, he was in the emergency room. It was determined that he was intubated. He was unable to breathe by himself. The next morning, he was extubated around, I think, sometime mid-morning or late morning. In the early afternoon, a psychiatrist, hospital staff psychiatrist, Dr. McGovern, was sent to interview the defendant because the standard protocol in the hospital was when there was a suicide attempt, it was a standard protocol for them to do a suicide risk assessment, send the psychiatrist to interview.
Hey, can I ask you a legal question before you fill us in on the facts to the extent you have to? Can we apply the 233-20BC exception where there was no finding by the motion judge or trial judge as to necessity or interest of justice?
Well, I think you can, and I think this court, because the court reviews de novo the findings of the judge below, and the question of the not the factual findings, but the legal conclusions. So I think the analysis, like set out in Commonwealth versus Seabrooks, this court went through the analysis and set out a number of factors that should be considered in determining whether a statement should be admitted, and just as Your Honor states, in terms of in response to, in regards to Section C, subsection C.
Don't you lose if we apply that exception?
I don't think so. If you'd like, I can go
Sure,
through those
please.
now. I think that, well, first, if I might, so the statute, if I can just step back to the statute itself. I think it's under the statute, well, if you're, the statute itself, I think the statement qualifies as a confidential, as a communication under the statute and is privileged under the statute. So maybe I'll come back to that.
I think the Commonwealth concedes it's a confidential.
Well, just.
Well, I take that. We'll let Mr. Seinfeld talk for himself, but I think that there's a concession that there was a doctor-patient relationship at least.
Right.
Okay.
I think they concede there's a confidential relationship. I think they contest that there was a confidential communication.
Right.
And Judge Lowy, as the motion judge, found that there was the privilege did not apply because, for that reason, he found that there was not a confidential communication, because the presence of the police officers sitting in the hospital room meant that there was no expectation of confidentiality and the privilege did not apply. But if you take a look at the statute, the plain wording of the statute, under the way the legislature has written the statute, there's no requirement of.
Are you leaving the first argument? Because have you addressed Justice? Are you?
No,
okay.
I haven't.
Okay.
I can do that right now.
Yeah, because I don't want you to. Before you move to the second part, I'd like to
Sure.
understand where you are on the first one.
Sure.
And could I add one just additional fact to? In Seabrooks, did we have trial court fact finding?
Yes.
Because we don't really have that here, right, on that issue. We don't have findings on the second issue.
Right. It was never reached, again, because the motion judge determined that the statute that the privilege didn't apply.
So just when you address Justice Gaziano's question, I just want to make sure I understand how it would work where we don't have underlying fact finding on that part of can we still do it?
I think based on the factors that, based on the factors that the court set out in Seabrooks, the first factor is looked at in Seabrooks, and again, none of these are dispositive in and of themselves, but totality of the circumstances must be viewed. The first factor in Seabrooks that the court looked at was whether there was an ongoing relationship between the psychotherapist and the patient. In Seabrooks, the court determined that there was not, because it was a first meeting, and the court determined that that I think fell in favor of the Commonwealth. However, there's another case which is where the court found the opposite, and that
I'm sorry, found the opposite, meaning that there
Well-
was no, that was not a factor, or?
no, I'm sorry. In Robinson, this court determined that there was the same situation where there was just, in Robinson, what happened was the defendant was in the hospital. She arrived at the hospital because her daughter was ill. The hospital thought that she could benefit from talking to a psychiatrist, psychotherapist. They sent someone to talk to her. There was one interview that lasted 45 minutes. No other ongoing relationship besides that. The communication was initiated at the behest of the hospital staff. This court in Robinson found that that was a privileged communication under the statute. So I think, so in answer to your question, I think the court, based on the record, I don't know that additional fact-finding is required. I think the court,
So under the exception, as I understand it, and I think this case is very similar to Tran as far as a fleeting relationship, doctor-patient, albeit a relationship. We have to find that your client inserted his mental condition, which he did, and then we have to find that the interest of justice would be better served by the admission of the statement, or words to that effect, correct?
right.
And my question, I guess, to be more precise, is can we make that interest of justice finding as an appellate court where it wasn't done by the motion judge nor the trial judge?
Again, I think you can based on the case law, but you are, to some degree, I think it's an interesting question because, as you know,
Right.
because
Most of his
the way the
questions are very
statute,
interesting.
Sometimes, yeah.
the way the statute is written is very broad. Not only, so it covers any communication between a patient and psychotherapist, and then when it gets, so there's three different, I think it's C, D, and E, that all provide for this balancing test, the interest of justice against the question of this, protecting for better word, the sanctity, whatever, the value of the patient psychotherapist privilege. And that's broad as well. And so,
Is that dependent on fact-finding, or is that a policy type of question? Because I'm just trying to understand, are there any missing facts that prevent us from doing that type of analysis? Because the first fact, the fleeting nature, we can decide based on the amount of time in the relationship, right? Is there any factual issue that would require development as opposed to this kind of open-ending balancing?
well, the second factor, which was the truth, is looking at the truth-seeking function of the trial. I think that if you look at what the court has done, what the court did at Seabrooks, looked at the testimony that was presented at trial by the experts, and what was relied upon and what was testified to. So in this case, I guess this court.
Yes, in the statute, though, it says the patient introduces his mental or emotional condition as an element of his claim or defense. We certainly have that. But then it says, and the judge or presiding officer finds it is more important to the interest of justice that the communication be disclosed and the relationship between patient and psychotherapist be protected. So doesn't that limit that inquiry to the judge or presiding officer, which would entail somebody at the trial level?
Perhaps it does. And in fact, in Usin versus Usin, where this court found that the procedure was not strictly complied, the statutory procedure was not strictly complied with, the court reversed and remanded.
Now, wholly apart from the testimony of Dr. McGovern, I assume that Dr. McGovern's report was given to your expert.
It was.
And did, I've not read your expert's testimony, did that particular doctor testify to the content of what Dr. McGovern heard?
The prosecutor asked asked the expert whether Dr. Joss, whether he was familiar, whether he was aware, I think was the question, that the defendant said that the weekend before the murder he was thinking of hurting his girlfriend. The doctor answered that yes, he was. So I don't think there's a question that they all reviewed Dr. McGovern's report. The Commonwealth's expert did not testify to the content of the report, but he reviewed it. So the experts did review Dr. McGovern's report.
And that was done purely pursuant to reciprocal discovery after he had declared his intent to maintain a defense of criminal responsibility.
Right.
So there was disclosure to Dr. Kelly on behalf of the Commonwealth with regard to that.
Right. Yes.
And does that bear on this analysis, or is it irrelevant to that? I mean, if it was truly privileged, of course, would not be furnished to Dr. Kelly, who was not the defense psychiatrist, but the Commonwealth's expert.
I think so, and so if the determination had been made at the motion to suppress, then yes, I mean, I think it does bear on. I think it compounds the error, it compounds any error if there's an improper disclosure at any point, if that's what Your Honor is asking.
Well, let's assume that the motion judge had said, this is a communication within 20B, and therefore it is not to be admissible. I would still think you'd have to furnish it to your expert, and if you gave it to your expert, you'd have to give it to the Commonwealth's expert, wouldn't you?
And yeah, and there were parts of that report that would be admissible. It's so the part of her examination was about the patient. So so I think it could be that just the statements could, I mean, it could have been used for an opinion, as a basis for an opinion, but the statements didn't have to come into evidence. That would have been one possibility if the judge had determined that the statements were inadmissible because they were privileged and didn't fall in the exception. The report could still function as information and basis for the expert's opinions, but the statements as they came in, that was improper. They came in through the prosecutor referenced it in opening argument. They came in through a police officer who was sitting in the hospital room. He was the last witness that the Commonwealth presented, and it was the last question asked of him. And
To go back to what the chief asked you, were those statements coming in anyway on cross-examination because they did come in on cross-examination of Dr. Joss?
well, they came in again. They came in. The prosecutor asked if he was aware of them.
I have,
So,
I have it in
but
front of
there
me.
was
It said, in fact, he stayed to her over the weekend before Esther was killed. The thoughts of hurting her because she was the cause of all my problems. I did read that. So,
Right.
So it came in.
Right. But it came in again on cross-examination.
Right.
So it didn't come in through the defense. So it didn't come in through the defendant asking his own expert about those statements. It came in through the Commonwealth's police witness. It came in through cross-examination of the defense expert, and then it came in through Dr. McGovern's
Right,
testimony.
right. Came in, 3, 4. Yeah, right.
Right. And interestingly enough, the police officer testified that he heard the defendant say that he had been thinking of killing his girlfriend, and Dr. McGovern testified that she heard him say he had been thinking of hurting his girlfriend. Her report, which was admitted as a hearing exhibit, I believe said hurting. It's just so it again points to the problem, the underlying problem with the police sitting in the examining room, in the hospital room, listening to this conversation.
The police need to guard him, right? There's no question they've got to keep track of him, right? So I'm trying to understand, normally if you have a privilege and you reveal information, attorney-client privilege, good example, you lose the privilege, right? Why isn't that the case? He's been in this hospital room for quite a while, right? Overnight. What time does this take place the next morning?
The interview takes place early afternoon, 1 o'clock, 2 o'clock.
So it's really hard to imagine that he's not aware that there are two police officers there when he's speaking to the psychiatrist, right?
Well, a couple things. In terms of the need for the police to, is your first part of your question, securing the defendant
Right.
or security. This testimony is handcuffed or shackled, somehow secured, physically secured to the bed. The police testified that he was cooperative and
You think it's okay to have someone who just brutally murdered their wife not be guarded by the police?
No, I think that the guarding is fine. I think what happens is when the psychiatrist comes into the room and says, I'm a and no Miranda is given, which is fine, they're not questioning him. But,
The police,
question of whether it's
the police
functional
have, the police have to leave.
exactly. Either they have to, well, they could, they don't have to leave, they could move far enough away. Again, the defendant is shackled, handcuffed, somehow secured, physically secured. So if they move somehow far enough away so they're not listening to the content of the substance of the conversation. When a psychiatrist comes in, they were present during when other medical personnel came in to, do whatever they were doing, treat the defendant.
But there's no allegation that this was somehow nefarious, that the police did this intentionally, that they knew a psychiatrist was coming in, they're trying to eavesdrop, right? They just were there.
No, but if they're in the situation, I think if they put themselves in this situation, which they did, and I recognize the necessity for security in the hospital and treatment, but if they're in that situation, then it's not a burden for them to either give warning. And another part of this is no warnings were ever given to the defendant. No warnings from the psychiatrist in terms of the limits of confidentiality of the statement. No warnings from the police in terms of Miranda. So that's another option. If you want the police should be able to stay for security reasons, then give some warning to the defendant, either through the police, through Miranda, or through by the psychiatrist through appropriate warning about the limits of confidentiality. But
When she comes in, does she introduce herself? How does she introduce herself?
as a psychiatrist.
She does as a
And
psychiatrist.
the police knew she was a psychiatrist.
Okay.
And she was doing I included in the brief in the record appendix, she was doing a suicide risk assessment, which is designed to get at, it's a probing psychiatric interview designed to get at someone's thoughts, which is why she asked the questions. Are you thinking of hurting yourself? Are you thinking of hurting anyone else? That was part of the assessment.
Let's assume for the moment what was not the case, which that she was alone with your client. She questions him, she obtains information from it, you then go to trial, and you argue lack of criminal responsibility. What do you say should happen to her report?
Well, in terms of his statements, they should not come into evidence. In terms of other conclusions that she reached, for example, if she reached, she made observations of the defendant.
Isn't this the most probing part of his mental state immediately thereafter? The first mental health professional that talks to him right after the crime is Dr. McGovern. So wouldn't the experts need to or should consider in a truth-telling process what his mental state was right after the crime?
Well, that's why I think there's other parts of her, in terms of the use of the report, it's one thing for them to read the report. It's another thing for the statements, for example, to come into evidence. So if the report is relied on to form opinions, the opinion can be, so Dr. Kelly can use the report as part of what he reaches opinion, but he can't testify to the specific statements.
But when your expert says that Dr. Joss testified that he was not criminally responsible, it's certainly fair game to say, isn't it true that he told this other psychiatrists that he was contemplating hurting her the day before the killing.
Well, again, if the statement, no, if the statement is privileged and should not be, and is inadmissible, then the comment, either direct testimony or the question regarding it.
So you're saying that when a defendant claims criminal responsibility, that the prior psychiatric reports of that individual should not be made available
No,
to the Commonwealth and should not be the subject of cross-examination if they are inconsistent with the opinion of the defense expert?
No, they should, I'm not saying that they shouldn't be made, they should be made available. I'm saying that the statement itself, which was inadmissible, shouldn't be referred to either through direct testimony or elicited through that it existed through cross-examination.
Any cases say that?
Well, I think that's the problem. I think that this case presents a unique situation where again, I think that, and I see my,
Oh, I don't think we still want to answer this
You
one.
can finish your answer.
but no, I think the unique situation, the unique circumstances presented by this case where the police are contributing again to hearing, they're sitting there listening to the statement. If they hadn't been there, the statement's privileged. I think the privileged statement doesn't come into evidence based on on 23320B, and no reference to to that statement. There could be other findings in the examination.
What are the best cases we should look at? I understand you say this is an unusual case, but what are the best cases that we can extrapolate in your favor or against you?
Seabrooks, which is where the court went through the factors. Robinson, which
But I'm talking about in relation to the chief's question about excluding. You're saying this stuff should be turned over, but it can't be used. I'm just trying to see, are there any cases that in any way guide us on that question?
I'm not sure there are. I could, if the court would entertain a post-argument letter, I could take a look. But I don't have any at hand. I mean, I think that, again, that if the statement's not privileged, then it just doesn't come in. It can be looked at, it can be turned over through discovery, but it doesn't come into evidence.
All right, thank you.
Thank you.
Mr. Steinfeld, good morning.
Thank you. Good morning. May it please the court, Kenneth Steinfeld for the Commonwealth. I think the court is properly focused in this morning on what may be termed a problematic part of the case, which was the absence of a finding either by the suppression judge or by the trial judge of the balancing of the interest as contemplated by the exception C to 20.
So do you still get the exception? Do you still get, you get the benefit of the exception?
Yes, I think I do, for several reasons. The claim is not made that this court cannot consider that exception because no finding was made. So this court can review it pursuant to the substantial likelihood of a miscarriage of justice standard or pursuant to its 33E power. And in that view, I think that Seabrooks is directly on point, and the record is filled with all of the information that the trial judge would need or that this court would need to find that the interests of justice were
What about the language of the exception that says the presiding judge applies it, not us?
well, but if the question is whether there is a substantial likelihood of a miscarriage of justice or 33E review, then I think that the lack of strict compliance with that rule does not automatically mean that the defendant's entitled to have his conviction reversed. In light of the fact that all of the factors, it is somewhat facile, but I think it's true to say that if the question had been presented to the court, I find it hard to believe, though it's possible, the judge would have found that the Seabrooks factors had not been satisfied and that it was not more in the interest of justice to have the discussion disclosed than to preserve the psychotherapist patient privilege here.
Why is it a substantial likelihood analysis, right? He objects to the introduction of this evidence, right?
Yes, but he does not claim on appeal that the lack of a finding by the trial judge precludes this court from reviewing it. He, in fact, says in his brief, and he said here today, this court can and should decide.
But I don't think he's suggesting that we apply a substantial likelihood, maybe he is, but
No.
I think he's saying that you can do this yourself, but it's like a de novo almost.
Yes, that's correct. And I think that if you do that, I think then that the evidence is overwhelming, that the statement should have been admitted for that reason. If this court were to do as the defendant asked and sit as the trial judge to review.
But don't we still have to review the decision by the motion judge for error before we get there?
Yes, but he did not address the question.
Right, of course, but
And so I think that the error would go solely to whether or not the privilege applied or if the statement itself was voluntary. Whether or not its admission at trial was error, reversible error.
well, right.
I think that's what's before the court. And ultimately, my argument is going to be that it doesn't matter because of the overwhelming nature of the evidence, that he had criminal responsibility. But I think that the record is so supportive of a
So this is belt and suspenders. You're saying to us that were we to find the motion judge's decision to be error, it wouldn't be reversible error because of the 20 VC exception.
I'm sorry, Judge, could you ask that question again?
I'll try. If we were to find, we don't get there unless we find there was error
That's correct.
under your analysis
Right.
by the motion judge.
Right.
Okay.
Or by Judge Welch at trial, because the defendant did actually renew his claim. He brought a motion in limine before trial. He did not ask for the finding to be made. But I think that I can agree that it is the Commonwealth's burden because it's an exception to a privilege. The proponent of the privilege has the obligation to show that it applies, and the opponent has the obligation to show that the exception applies. And that here was the Commonwealth. So I agree that the Commonwealth should have said to the court, would you please make a finding? But I don't think the fact that it was not made means that the admission of the statement was reversible error.
But just to be clear, the motion judge did two things in deciding. First, he decided the issue of voluntariness, and I believe you're telling us that that was correct.
Absolutely.
Okay,
And
so the issue was not the voluntariness. The
That's
issue
correct.
was whether or not it fell within the privilege of 20B and because of the presence of or despite the presence of the police officers. And I believe your position is that where they needed to be there because they needed to maintain the security of the prisoner and arguably protect the psychiatrist, that their presence did not destroy the privilege, much as the presence of an interpreter would not destroy the privilege.
Well, it is not so much that they had to be there, but that they were there and that the defendant knew that they were there. But it does mean that there's almost no alternative to having this happen. It's unfortunate, but I think that due to the nature of the offense and the possibility of a suicide attempt, that there's really almost no way to avoid this. I don't think it would be reasonable to ask the officers to leave the room, even though he is shackled. She's right there next to the bed. And I think that if she were to stand like 8 or 10 or 12 feet away, that might affect her ability to get honest answers from him. So I think it's pretty safe to say that those officers had to remain in the room. What I'm saying is because they were there and because Judge Lowy found, if not explicitly, then certainly implicitly, that he was aware that the officers were in the room, that the general overarching principle that runs throughout privilege law, that if a statement is made in the presence of a non-essential third party, then the privilege does not apply. I think that general rule just applies here of its own force. And of course, the psychotherapist patient privilege is solely statutory. There is no common law psychotherapist patient privilege. So the general rules that apply to privileges generally, there's no reason why they should not apply here to this statutorily created.
The language is pretty broad. In any court proceeding, a patient shall have the privilege of refusing to disclose and of preventing witness from disclosing any communication wherever made. I'm just wondering, does that override the fact that it's made in the presence of somebody else?
No, I don't think, I think that the language is also very strict in the in the priest penitent, in the social worker, in the various other categories, attorney-client, you know, wherever made, I don't think brings in, means that the general rule that if it is made, if it's knowingly made in the presence of third parties, that the privilege doesn't apply.
Could you address the chief's question, which is that this stuff is gonna, I mean, once he puts his mental state in play, there's no way of not using this information? And are there any cases guiding us on that question? Because your brother is arguing that we should exclude this probative but prejudicial statement, right?
Right. Both Dr. Joss and Dr. Kelly for the Commonwealth said that they reviewed and they relied on Dr. McGovern's report, which included her statements. And in Seabrooks itself, it says where the two experts take a look at the same evidence and reach different conclusions, as happened in this case, the jury has to know what the content was of the materials that were reviewed by both Dr. Kelly and Dr. Joss. So the fact that the doctors relied on Dr. McGovern's report makes it essential for the statements made by the defendant to Dr. McGovern be known to the jury so that they can decide between the experts, Dr. Joss and Dr. Kelly, which one
So
is
the
more
best
credible.
case for us is Seabrooks to look at?
Absolutely, yeah. I think that Seabrooks and to some degree the footnote in Brandwine, but I think Seabrooks is as close a case to this one as you're going to find, although I do admit that in that case the trial judge made a finding pursuant to 20 BC that it was in the interest of justice. That's the only difference of that case from this case. But factually, they are incredibly similar.
And are there any facts that we need to sort of look at that the trial judge doesn't develop?
No,
Okay.
no, they're all in the suppression record. The term of or the duration of the relationship with the psychiatrist, the use of his statements, the fact that the defendant did not discuss the crime or his suicide attempt with the doctor, everything that's in Seabrooks is patent on the record in the
Well, he
in the suppression
discusses the
hearing.
crime, right? I mean, he discusses his motive for the crime.
Well, but he says he has no memory of it, and in Seabrooks, it says that he had the defendant had an opportunity to speak to his lawyer beforehand, which is a difference from this case. But the lawyer there said, "Do not discuss the crime," and here the defendant did not discuss the crime.
Had the defendant been Mirandized in Seabrooks too?
I don't believe so, but I'm not certain. It certainly was not part of the analysis. It is accepted law that in terms of voluntariness, at least, and also for privilege, I think that it doesn't matter when a statement is being made to somebody other than a police officer, the presence of a Miranda warning does not affect either the voluntariness of the statement or the applicability of a privilege to it. So I don't think it matters either way, but I do not think that he was in fact, I'm almost certain that he was not in Seabrooks because it was Dr. Sherry who had come to do the suicide risk assessments afterwards, and he met with him 5 times.
You say you have another way of winning too, right? So you have in your view, you have 4 different ways that, right? 1, that you lose the privilege. 2, the 20BC balancing. 3, the chief's questions. And now 4, you're going to say that the evidence is overwhelming, right? Do you want to go over that?
This is among the weakest criminal responsibility cases that I think I've seen, and certainly...
Well, he actually had a documented history of mental illness. There are lots of criminal responsibility cases
Sure.
without a person being on risperidol and being diagnosed with bipolar
Sure,
disorder.
but documented illness that
So
none of the...
I guess it's your characterization of the weakest you've ever seen.
I
I quibble with, but...
Well, there's 2 aspects to that. The way that he behaved immediately before and immediately after was very, very strong evidence. But more importantly, the diseases for which he'd been diagnosed, there's no connection in the record, or as far as I know in the psychiatric literature, between those diseases and this kind of conduct. Yes, he has a history of mental illness, but under McCool, that illness has to result in his lack of substantial capacity. We heard all about what the characteristics are of a person with manic depression when he's in the manic phase or in the hypomanic, and the expert testified that hypomanic means a shorter lasting mania than in ordinary bipolar disorder, and the characteristics of somebody who's in a depressive phase. And none of them includes memory loss, blackout, violence. These diseases do not cause someone to act the way this defendant did. In all of the cases where there is a documented history of disorder, they involve psychiatric disorders that involve delusion, mania, paranoia, dissociative states, auditory and visual hallucinations, something like that, something that is consistent with the behavior. Here, both Dr. Joss and Dr. Kelly said that it is very atypical for people with manic depression or bipolar disorder to commit acts of violence or to threaten other people. So there's no evidence of causation that his mental illness, to the extent that he had one, and Dr. Kelly said that he was not, but the jury certainly could have found from Dr. Joss's testimony that he did, that that particular mental illness could have caused him to lack substantial capacity. There's no evidence of that at all, nor is there any evidence that he actually lacked substantial capacity, either to appreciate wrongfulness or to conform his conduct on the day of the killing. And I think I've cited a whole bunch of cases about that. There is nothing that says, and doctors didn't say, that it's possible that you could lead a totally normal life and day and then snap because you have bipolar disorder and blackout and then commit horrible acts of violence and then all of a sudden come to and realize or not know what you have done. Also, the fact that the killing was so specific, and he had said that he was going to do it before and that he was going to get away with it because he had bipolar, which is also very, very strong evidence that he had the substantial capacity at this time. The fact that he did not injure his daughter while he was stabbing her and she was crawling underfoot, nor did he injure Ruth. He only injured the two people whom he had previously threatened, the sister Margaret and his ex-girlfriend Esther. And so the fact that he had the capacity to do that and to stab her 20-something times without injuring anybody else, these facts do not display somebody who's in the grip of a blackout. And as I said, he had no disorder that anyone said could have caused him to act the way he did. And that's why I say this is an incredibly weak lack of criminal responsibility defense case.
So what is the standard of error? Is it prejudice? I mean, if you admit into evidence a privileged communication and that is error, what is the
Yes, it is preserved, so the standard's prejudicial error.
prejudicial error?
Right. As to voluntariness, it is harmlessness beyond a reasonable
Right,
doubt.
but you contend
No, but I
that-
concede that it is prejudicial error because his rights were definitely saved, both by the filing of a motion to suppress and also on the first day of trial. Judge Welch said that his rights are saved as to that issue. So I'm not saying that it's waived at all. His claim that the statement should not have been admitted because it was privileged is preserved and is reviewed for prejudicial error.
So, and going back to Justice Gaziano's very first question,
Sure.
are you saying we have the authority to make that finding or to determine that this is a finding never made?
That's correct.
If the finding had been to the contrary, would we have the ability to review it and say it was abuse of discretion?
Well, you certainly have the ability to see whether or not there was factual support for the findings. You'd have a limited and a deferential view, but I think 33E gives this court the power to review it. But as I said, it is a problematic element of the case that there was no such finding by the trial court.
Right. I mean, I'm just wondering,
yeah.
it's whether or not our authority is different where there is no finding, as opposed to if there were a finding, of course, it would it would have to come to us in interlocutory if you had lost.
Of course.
Whether or
Of
not
course,
we'd have the ability to say, no, it is, the interest of justice clearly require its admission, and therefore it would be error for a judge to find to the contrary.
Right.
And here we don't have a finding.
I fully appreciate the situation in which we find ourselves, and I certainly understand your concern. And the argument that I've given is my answer to that. I hope the court finds it compelling, but if it does not, then I don't think that there was any prejudicial error.
Okay, we all play the cards we're dealt.
I tried. Thank you very much, Your Honor.
Thank you.